My Lords,
Yes, Mr. Seagham.
before I begin the substantive submissions, my Lord Reid asked yesterday about Section 91 of the Communications Act 2006, that being the provision under which the appeal to the Supreme Court originally arose. The answer to my Lord's question is that the grounds of appeal are in subsection 2 thereof. They certainly do include error of law, albeit they're not limited to error of law. I do have physical copies, but I'm also mindful of the guidance that's been issued by the board that you prefer to receive things by email rather than physically, and so I'm in your hands.
I think we can be flexible enough to allow you to hand up the documents.
I'm most grateful, my Lord. Let me give 5 copies. Yeah, thanks, George. Thank you.
Thank you.
And it's subsection 2.
And in the present case, was the appeal on the ground of error of law?
Yes, it was. Whether it also included any of those other subsections, I can't say on my feet. But yes, it certainly included error of law. When we broke, I was in the middle of my second main topic, which was a brief summary of our core case on why power exists to order the access sought by my client. And we'd looked briefly at Article 5, to which we will, of course, return. As your lordships know, we submit, in agreement with the Court of Appeal, that Article 5 requires the conferral of a general power for national regulatory authorities to ensure adequate access, if that's required in a particular case, by the objectives pursued by the common regulatory framework and subject to the relevant safeguards. And that was, we say, confirmed in the very first CJU case concerning Article 5, which was Commission and Poland. Now, just to introduce the case briefly, in that case, Polish law had obliged all operators to negotiate not just interconnection, but also access in the broader sense, and had given the president of the NRA, the Polish NRA, wide powers of intervention to implement that obligation. And Polish law was found not to satisfy Article 4 of the Access Directive, because the obligation operated on a mandatory basis without any assessment of the facts of a particular case, as we'll see. But critically for our purposes, the CJU rejected a submission that Polish law breached Article 5 of the Access Directive precisely because that article required a broad general power of intervention. And I can start with the Advocate General on this issue because the CJU, in fact, referred to his reasoning on the issue. It's in Authorities tab 18 at Electronic Bundle page 1213. You can see from paragraph 1 on page 1213 the 2 complaints that the Commission presented. It sought a declaration that the Republic of Poland has failed to fulfil its obligations under Article 4(1) and the first subparagraph of Article 5(1). So those were the 2 complaints. The Advocate General, I can take you next to paragraph 29 at page 1219, made some general observations about the purposes of the Common Regulatory Framework. Paragraph 29, since the dawn of liberalisation of telecommunications, the Commission has made clear its concern about access to essential facilities and has taken action in cases of abuse where undertakings with exclusive rights to the infrastructure required to provide a service refuse to allow competitors access to that infrastructure. and I think I can then go on to 31. The implementation of freedom of competition was not sufficient, alone, so that's ex post competition law, which we were discussing to some extent last night, was not sufficient to establish fair competition. The de facto monopoly of former public operators and their long-held rights, together with their detailed knowledge of the market and the privileged position that they had occupied, meant that it was necessary to encourage the emergence of other undertakings by introducing accompanying measures in their favour. I can then move forward, please, to paragraphs 63 to 65, which make a point which I'll be coming back to later. It's page 1225, about the distinction between interconnection and access. Paragraph 63, furthermore, the fact that the Polish law treats access and interconnection in the same way for the purposes of Article 4 of the directive unquestionably supports the claim that Poland has failed to fulfil its obligations. Interconnection concerns relationships between individuals, is similar in nature to a private law institution, and constitutes a mechanism for interaction between differently designed networks. By contrast, the concept of access gives rise to more far-reaching legal effects than the simple interconnection of infrastructures, in that it entails making available a whole range of facilities or services, including interconnection, which is a specific type of access implemented between public network operators. And then one can move forward to the second, where the second complaint is dealt with. That's the one concerning Article 5. That's paragraph 69 onwards at page 1226. Your Lordships can see the Commission's argument in paragraph 69. The Commission maintains that in accordance with Article 5.1 of the Access Directive, national regulatory authorities must be given the power to intervene specifically in order to ensure compliance with the objectives set out in Article 8 by laying down transparent, proportionate and non-discriminatory conditions, and claims that the Polish law does not provide for those exceptional powers. There's then reference to Article 8, which I've already shown you, the tasks of national regulatory authorities, the competition objectives. Then the Advocate General makes reference to the fact that, in line 4 of paragraph 71, the particular legislative technique used for directives occasionally creates a high degree of abstraction in order to allow the Member States sufficient latitude and thereby maintain their effectiveness. There is a reference on the facing page, page 1227, in paragraph 73, to the point which I've already made, that Article 8 of the Framework Directive has been construed as placing an obligation on Member States to ensure that the national regulatory authorities take all reasonable measures aimed at promoting effective, unimpeded competition. And then we can go, please, to paragraph 77. The Advocate General says, for the purposes of resolving the difficulty, it must be noted that Article 5.1 of the Access Directive imposes on regulatory authorities the continuing obligation to analyse the market in order to encourage and ensure adequate access and interconnection and interoperability of services. We then have, over the page, 1228 at paragraph 79, Article 5 of Directive 2002/19 provides in particular for a number of obligations which the regulatory authorities must be in a position to impose. Paragraph 80, however, those obligations are not laid down in a restricted manner, but rather in a way which allows national regulatory authorities sufficient latitude to impose them in conditions of efficiency, sustainable competition, and maximum benefit to end users. So the point is latitude. The Advocate General then makes reference to an earlier judgment of the Court under an earlier directive, Telefonica de España, in paragraph 81, which concerned the powers of NRAs under Directive 97/33. Paragraph 82, that judgment which concerned the Kingdom of Spain, and then there's a reference to providing the Republic of Poland with less ephemeral protection than Frédéric Chopin and George Sand found at the Carthusian monastery of Jesus of Nazareth. The point is explained, or certainly was explained to me then, in the 9th line, where the Advocate General says the court held that the former were granted a wide range of powers, so that in addition to encouraging negotiated agreements between competitors, they were also entitled, so this was the interpretation that had been arrived at of the 1997 directive, they were also entitled to impose an ex-ante obligation to provide access to the local loop and interconnection at local and higher level switching centres. Paragraph 83, in light of those factors which demonstrate that the powers of the regulatory authorities are not clearly defined, the argument of the Commission is vitiated by a lack of proof and is incompatible with the complaint that Article 5 of the Access Directive was incorrectly transposed, since, in line with the foregoing considerations, Articles 26 to 30 of the Polish law on telecommunications afford the national regulatory authority wide powers of intervention. And I obviously emphasise those words, wide powers of intervention, because the court later comes to them. And then paragraph 85 refers to the aims of the body of law being reflected in the body of provisions of Polish law. Now, the court endorsed that reasoning and added to it, that's tab 8 at page 928. And the second... Sorry, page 928.
928, thank you. 928.
And one can see the second complaint begins at page 954, paragraph 50. The second complaint based on non-conformity with Article 5. And it's important that I then point out that the paragraph that Sir Peter relied on yesterday at page 955, paragraph 51, is a submission by the Commission in support of a case of incompatibility that was rejected by the court. So in my submission, these are the submissions that were rejected by the court. The Commission said that Article 5.1 cannot be implemented by a general statutory provision since it requires national regulatory authorities to be empowered to act only in certain cases, etc. What you will see then at paragraph 61 onwards is the findings of the court which reject that case. Paragraph 62 refers to, this is page 958, refers to the regulatory tasks of the National Regulatory Authority being set out in Articles 8 to 13 of the Framework Directive, which we've already seen.
Sorry, we're in paragraph.
Sorry, paragraph 62 on page 958. There's then reference again, as we've seen, to the Centro Europa obligation in paragraph 63. Paragraph 64. Secondly, the first subparagraph of Article 5.1 of the Access Directive refers to the powers and responsibilities of the national regulatory authorities in respect of access and interconnection, and then there's reference to what it provides. So I pause there to note that means the part before the words "in particular," as you will see when we come to the Telia-Sonera case. It follows that the first subparagraph of Article 5.1 of the Access Directive is limited to providing, and they then say this, a general power for the national regulatory authorities for the purpose of achieving the objectives of Article 5 of the Framework Directive in the specific context of access and interconnection. 66, as the Advocate General has observed in point 83 of his opinion, Articles 26 to 30 of the Polish law on telecommunications afford the NRA wide powers of intervention. Then there's a reference to a need to prove the alleged failure. And in paragraph 66, they reject the complaint that Article 5.1 cannot be implemented by a general statutory provision. So court endorses in paragraph 65, and indeed in this section as a whole, the proposition that Article 5.1 contains a general power for the national regulatory authorities for the purpose of achieving the objectives of Article 8. And it is held that that obligation is met by the conferral of what the Advocate General and the CJU would describe as wide powers of intervention. That is indeed, I would observe, exactly what the legislation in Gibraltar has done in implementing Article 5. You will see it, Authorities tab 4 is the Communications Act 2006, as in force at the time of the decision. This is an electronic bundle, page 842. This is the Communications Act 2006 as it was in force at the time of the decision, at electronic bundle, page 842. There's a definition of access in section 2.1 at page 843. There's the general definition and then the particular elements which are, as you will already have seen, described in Article 2A of the directive. I think it is common ground, I think, that this would have to be interpreted consistently with Article 2A and indeed the TDC case, which I'll be showing you in due course, which makes clear that it's non-exhaustive. But that may not matter for present purposes given the references to physical infrastructure. One then sees the reference in section 19 at page 860 to the Article 8 objectives. Page 860, the objectives of the authority in exercising its functions under this Act shall be as follows. In relation to the provision of electronic communications networks, electronic communications services and associated facilities to promote competition, and indeed subparagraph 3 to promote the interests of users in Gibraltar. Subparagraph 2, the authority shall adopt all reasonable measures which are aimed at achieving the objectives referred to in subsection 1A, including, and then A2 is ensuring there is no distortion or restriction of competition in the electronic communications sector. Subsection 3, well, actually, I should go on over the page 862. C, insofar as promotion of the interests of users in Gibraltar is concerned. And then we have in subparagraph 5, encouraging access to the internet at reasonable cost to users, and at 8, promoting the ability of end users to access and distribute information or applications and services of their choice. The reference to avoiding discrimination is at subparagraph 3B. And at 3C, we have safeguarding competition to the benefit of consumers, etc. So those are the objectives, and that is the obligation of the authority to take all reasonable measures aimed at achieving those objectives. We then have at section 34.4, page 864, the authority shall have a duty to ensure that there is established in Gibraltar a regulatory framework, page 864, section 34, subparagraph 4. There is established in Gibraltar a regulatory framework for securing adequate access, interconnection and interoperability of services. A general duty to establish a framework. And of course, that section means access in the broad definition which is in the Act and indeed in the EU framework. But one then comes critically to the access regulations themselves, which are at tab 5, page 873. Regulation 5.2 at page 876 requires an operator to offer access or interconnection on terms and conditions which are consistent with any obligations imposed by the authority pursuant to Regulations 6, 7, 8 and 9. And then Regulation 6 says this on page 877. The authority shall, having regard to these regulations and to its objectives as set out in section 19 of the Act, encourage and, where appropriate, ensure adequate access, interconnection and interoperability of services in such a way as to secure, and then one has the objectives we've been looking at. Subparagraph 2, without prejudice to any SMP obligations that it may impose pursuant to Regulation 9, the conditions which the authority may set pursuant to Sub-Regulation 1 include conditions which, and then we have the Article 5(1)(a), A, B and B. And they have even replicated A, B and B, as you will see. The same subparagraph numbering as appears in Article 5(1). So this regime implements Article 5 in a manner which is 100% consistent with our case as to the meaning of Article 5(1), and entirely inconsistent with the case that was advanced to you yesterday, that the conditions in Article 5(1), subparagraphs A, B and B are exhaustive. It's perfectly plain that this scheme anticipates, correctly we say, and in line with the jurisprudence of the CJU and indeed Article 5 on its ordinary interpretation, that the first subparagraph of Article 5(1), implemented here by Regulation 6(1), confers a general power. And that's confirmed again in subparagraph 5, page 878. Any obligation or condition imposed by the authority pursuant to sub-regulations 1 or 2. So again, this anticipates that conditions may be imposed pursuant to Regulation 6(1), which is the equivalent of Article 5(1). And for good measure, then Regulation 6 says the authority may, subject to these regulations and to sections 13, etc., exercise its powers on any matter concerning access or interconnection referred to in sub-regulation 1 on its own initiative. And in subparagraph 7, there is then an obligation to seek the achievement of the competition objectives in section 19 in exercising those powers. So that structure provides for a general power for the GRA to impose whatever conditions it wishes to ensure adequate access in the full breadth of that definition in order to promote competition. And the conditions at subsection 2 are expressly simply examples. And we say that that is the proper implementation of Article 5. As I'll be showing you, it's actually also, contrary to what Sir Peter said yesterday, the way in which the UK has implemented Article 5. Now, one might, of course, ask, given the breadth of the powers of a national regulatory authority under these provisions, what safeguards exist against a potentially exorbitant or erroneous exercise of those powers? And the answer is, as I showed you yesterday, that there is a suite of safeguards which the CRF and the Access Directive require to be observed when these sorts of conditions are imposed. And they fall essentially into 3 camps. First of all, there is an express requirement for a national regulatory authority to act proportionately and transparently in formulating and imposing the obligation itself. So that is Article 5(2) of the Access Directive, which specifically requires obligations and conditions to be objective transparent, proportionate, and non-discriminatory. And as I showed you yesterday, Article 8.1 of the Framework Directive emphasises the same point. It requires the measures to be proportionate. And that requirement is, as one would expect, given the EU law context, a serious and a demanding one. I'm going to be coming to the TDC case in a bit more detail in due course, but let me just show you very briefly what is said about the proportionality requirement and what it required in that particular case at tab 11, page 1035. And I'll be coming back to this case. This was an Article 12 case, but it's talking about the requirement of proportionality, including under Article 8 of the Framework Directive. Paragraph 50 on page 1035, NRAs must, when considering the obligation referred to in Article 12.1, and in particular when assessing whether such obligations are proportionate to the objectives set out in Article 8 of the Framework Directive, and then I won't read it all out, but there's a detailed explanation of the kind of intensive analysis of proportionality that is entailed by the proportionality requirement under these directives. So it's not a formality, it's a serious requirement. So that's the first safeguard, is the requirements under Article 5.2 of the Access Directive and 8.1 of the Framework Directive. The second safeguard is that a national regulatory authority is obliged to consult before imposing an obligation under Article 5. I showed you last night Article 6 of the Framework Directive, Authorities, tab 2, page 637. And as your Lordship's aware, a requirement to consult the person affected. And I also showed you Article 7.3, which is if it has an interstate effect, there are even broader requirements to notify a whole range of different people. Third safeguard, an undertaking has the right to an appeal from an NRA's decision. And that's, as I made the point last night, that is not just a judicial review. It's, as Lord Sumption emphasised in Telefonica, and as I showed you last night in Article 4 of the Framework Directive, it is an appeal in which the merits have to be duly taken into account, and that is an automatic right of appeal. So the powers are broad, but they are subject to both substantive and procedural restrictions and an automatic right of appeal in which the merits are duly taken into account. So we say the correct approach is relatively simple. The access sought in this case was plainly within the definition of access at Article 2A of the Access Directive. Indeed, no one seems to dispute that. That being so, the GRA had power under the first subparagraph of Article 5 of the Directive to impose it if it considered this to be an appropriate case, subject, of course, to the safeguards I've just outlined. And for good measure, that is exactly the framework that was actually adopted in the Gibraltar legislation which implements the provisions we've been looking at. And that is, we submit not just the right interpretation as a matter of wording, but also the only one which is consistent with the objective of the CRF, which is to enable national regulatory authorities to promote competition in the delivery of electronic communication services. And I addressed the board yesterday afternoon on the competition implications of the interpretation that's being advanced by the GRA and GibFibre. It's common ground that what Gib Telecom and Sapphire are doing within the data centre is delivering electronic communication services within the meaning of the CRF. That's paragraphs 3 and 4 of the Statement of Facts and Issues. It's also common ground that they do so, indeed they can only do so, by connecting their networks to the computer servers within the data centre. And I've showed you the references in paragraph 5 of our supplementary written case. So in the end, the case that's being advanced before you is that despite the relevant services being within the ambit of the CRF, simply because there is an indeterminate, as yet undetermined, quantity of what has been found to be private wiring connecting the customer's servers to the respective networks, the conditions of competition in that market for electronic communication services are no longer a matter for regulation by the GRA at all, and can simply be dictated by GIB Telecom alone. And the board should be very slow, in my submission, to adopt an interpretation that would leave the GRA powerless to address such an obvious and serious distortion to competition, as indeed the GRA has itself found. So the Court of Appeal was, we say, quite right in its reasoning in paragraphs 44 to 51. So that's a summary of our core positive case. I must now, of course, deal with the three issues in the appeal. That's my third overall topic. My Lords, the first issue in the appeal can be seen at paragraph 15 of the Statement of Facts and Issues, which is in the Key Documents bundle at tab 1, Electronic Bundle page 510. And the issue is this: does Article 5 of the Access Directive endow the appellant with a general freestanding power to require access as defined in Article 2A to be granted for the purpose of the attainment of any of the objectives in Article 8, or are the powers of the appellant to direct the grant of access under Article 5 limited to the purposes and circumstances listed in paragraphs A, B, and B of Article 5? So the issue is whether or not the cases listed in the sub-paragraphs of Article 5.1 are or are not exhaustive. The GRA says they are exhaustive. That contention is not supported by GIB Telecom. GIB Telecom accepts, rightly we say, that the cases stipulated in those paragraphs are not exhaustive. That's GIB Telecom's written case at paragraph 46, subject, of course, to their other point that arises under issue 2 and to which I shall be coming. The GRA's case on issue 1 was refined in Sir Peter's oral submissions yesterday, and he summarised his case on interpretation yesterday shortly before lunch in a series of propositions which I understand to be the case that I have to meet. Those propositions were that Article 5 provides a general power, but it must be exercised only where appropriate, and as regards access, that means only by way of obligations under Article 12, so that's SMP obligations. That was the first proposition. The second proposition was that the first subparagraph of Article 5.1 does not create any power to impose access obligations on non-SMP operators at all. And then the third proposition was that the second subparagraph of Article 5.1 tempers this by allowing specific conditions to be imposed on non-SMP operators. So essentially the case was that for SMP operators, access can only be dealt with under Article 12, and for non-SMP operators, access can only be dealt with under the specific sub-paragraphs A, B, and B, which it was submitted are exhaustive and exist in effect to temper what would otherwise be a complete absence of power to ensure access as regards non-SMP operators.
Shouldn't it be Article 8 not Article 12? I thought. Oh.
Well, I'm obviously speaking from my note of what Sir Peter said. It may be that.
I mean, surely it's Article 8 then that introduces the range of measures for operators with SMP, of which Article 12 is only one.
I'm sure, Your Lordship.
That was how I understood it, anyway.
My Lord, my note is that as regards access, it was only by way of obligations under Article 12.
But there are others that refer to access. I mean, it's not there. Then they all refer to access and the particular obligations.
Well, my lord, I'll attempt to address it on both hypotheses, but as I say,
Yeah.
I'm recapitulating what I understood to be the case, and I'll attempt to meet both versions. And my lords, essentially we say there are four fundamental problems with the GRA's case on issue 1. Firstly, it is inconsistent with the core reasoning of the Court of Justice in Commission and Poland. Secondly, it is inconsistent with the wording of Article 5 itself. Thirdly, it is inconsistent with the CJU decisions in Telia Sonera, TDC, KPN, and Polkomtel, all of which I'll be showing you, which explicitly reject the proposition that the cases stipulated in A, B, and B are exhaustive. And fourthly, it is inconsistent with the context and the purpose of Article 5. And let me develop those 4 points in turn. The first flaw, as I say, in the GRA's position on this issue is it's simply inconsistent with the CJU's decision on the second complaint in Commission and Poland that I've already shown you. Indeed, one might observe that the wording at paragraph 15.1 of the Statement of Facts and Issues, which the GRA says is wrong, at page 510, is in substance exactly what the CJU confirmed to be correct in Commission and Poland at paragraph 65, when the CJU described the first subparagraph of Article 5.1 as a general power for the purpose of achieving the objectives of Article 8 of the Framework Directive in the specific context of access and interconnection. Commission and Poland cannot sit with the idea that Article 5 is supposed to be a narrow, rigidly prescriptive provision. How could the CJU possibly have described Article 5 as a general power if the three means stipulated therein were intended to be exhaustive? And for good measure, as I've shown you, that's not how the Gibraltar legislation actually implements Article 5. The legislation is quite clear, in line with Commission and Poland, that the cases listed in subparagraphs A, B, and B of Article 5 are not exhaustive. That's the first problem. The second problem with the GRA's case on this issue, we say, is that it's inconsistent with the words "in particular" in Article 5 itself. These words indicate strongly that the cases listed in subparagraphs A, B, and B of Article 5 are not exhaustive. Sir Peter referred yesterday to the recall support services case, which you can find in Authorities tab 20 at electronic bundle page 1244. A decision of the Court of Appeal in relation to a Frankovich claim concerned with a different directive in the Common Regulatory Framework, the Authorisation Directive. And you can see at paragraph 5 on page 1254 the reference to the Common Regulatory Framework, the Framework Directive, the 4 specific directives, and you can see from paragraph 6 that in this case, the specific directive of particular relevance was the Authorisation Directive. You can see what the grounds of appeal were at page 1256. The appellants advanced the following grounds of appeal, and by 1A, they contended that the judge erred in her interpretation of Article 5 of the Authorisation Directive, and they submitted that public security was not available under Article 5 in its original form. And you can see the issue related to Article 5 of the Authorisation Directive, which is at paragraph 23, page 1260. And at this point, I hope your lordships will see, I hope I'm delayed too long in getting there, why this case is relevant. Article 5 of the Authorisation Directive said, Member States shall, where possible, in particular, where the risk of harmful interference is negligible, not make the use of radio frequencies, etc. And the question was, were the words in particular exhaustive in the sense that harmful interference was the only ground available, or was public security available as a ground because of the words in particular? And you can see that submission being advanced at paragraph 28, page 1262, paragraph 28. And that submission was rejected for various reasons, one of which, at the bottom of page 1262, the sentence beginning moreover, was moreover the very words where possible in particular indicate that the risk of harmful interference is not the only permitted ground of exception. And as I understood his submissions on this case, Sir Peter accepted the basic point that in particular does indeed connote non-exhaustive, and we agree, and that is inconsistent with the GRA's case on issue 1. Now, Sir Peter said that recall helps because it indicates that one has to work out what is within the scope of such a power by reference to the objectives and the context. But that is, of course, exactly what we and the Court of Appeal were doing, we say, by reference to the competition objectives which underlie the whole of the common regulatory framework. That's the second problem. The third problem with the GRA's case on this issue is that in 4 decisions, the CJU has rejected the proposition that the means set out in Article 5.1 are exhaustive. We've listed them out in paragraphs 21.2 to 21.5 of our written case. I should just show you briefly each of those decisions, and I'll take them chronologically. The first is Telia Sonera. The facts can be seen best in the Advocate General's opinion, which is in the Authorities tab 13, electronic bundle, page 1067. One point to pick up early on is at page 1068, paragraph 5. Neither of the main parties in the national proceedings has acquired the status of operator with significant market power. So neither party had SMP. And the basic dispute you can see at paragraphs 23 onwards, page 1073. IMEZ deals in text messages and multimedia messages by means of a software package in order that its customers may communicate with a mobile phone user, etc. There's a reference to how the software works. The company does not have its own radio network, but it does have message centres. There's a reference to the message centres. 25, the mobile telephone network of the company Telia Sonera allows the transmission of text messages and images and also data processing. And you can see from 27 that the Finnish NRA was asked to impose a solution for the transmission of SMS and MMS messages. And obligations were imposed in that regard, as you can see from 28 and 29. Now, I can then pick up the CJU decision at tab 12, page 1037. A further important point to note about the context emerges from page 1052, which is that in this case, the Finnish law, you can see this in the lower half of 1052, had applied an obligation on all operators, not just network operators, to negotiate interconnection. You can see that from paragraph 19 there, and the definition of telecommunications operator above. I emphasise that because it becomes important later in the reasoning, because the CJU held that that was incompatible with Article 4 of the Access Directive, because that was supposed to be restricted to operators of networks. That's paragraphs 26 to 48, and 48 is the conclusion in that regard. But the relevant part for our purposes is then the later section that deals with the third part of the first question, paragraph 56 onwards, at page 1063. You can see the question at paragraph 56. The National Court asks essentially whether an NRA may require an undertaking which does not have SMP to negotiate in good faith with another undertaking on the interconnection of SMS messages, etc. As a preliminary point, it must be stated that the necessary premise for the answer to the question is either that Article 4.1 of the Access Directive applies to the case, etc., then or, in the fifth line, that the situation at issue in the main proceedings falls outside the scope of that article, since one of the operators concerned cannot be classified as an operator of public communications networks. So it could be outside Article 4 altogether. Then paragraph 58. The answer to all of this lies, the court decides, in Article 5.1. It must be observed first that it follows from the wording of the first subparagraph of Article 5.1 of the Access Directive that the national regulatory authorities are responsible for ensuring adequate access and interconnection, and also interoperability of services, by means which are not exhaustively listed there. So completely consistently with Commission and Poland, the holding is that this is a general power, the means are not exhaustively listed in Article 5, and the court then says, in that context, in accordance with point A of the second subparagraph, so it's clear that the court is taking the view that the first subparagraph is a bit before in particular, and the second subparagraph is a bit afterwards. There's then reference to the particular case in 5.1a. Now, of course, I mean, on the GRA's case, what the court should have been saying at this point was, in this paragraph 59, however, the means are exhaustively listed in subparagraphs A, B, and B. But of course, that's not what the court says at all. It treats those paragraphs, rightly we say, as examples of a general power. Sir Peter relied on the word solely in the fourth line of this paragraph. But that simply reflects a provision of Article 5.1a itself, which, as you will recall, says to the extent necessary in the such like. So just reflecting the wording of 5.1a. There's no greater significance than that. Then, paragraph 60, Article 5.4 of the Access Directive also concerns access and interconnection and requires that NRAs be empowered to intervene, since it provides that those authorities may intervene at their own initiative in order to secure the objectives of Article 8, but without defining or limiting the detailed rules for that intervention. 61, thus it is apparent, and then the power is found. And you can see from the end of the paragraph that it includes or interoperability of SMS and MMS message services if the undertaking which makes the request is not covered by that classification. So that's not an operator of a public communications network. And that reasoning is not, we say, at all consistent with the idea that Article 5 is rigidly prescriptive. Indeed, paragraph 58 essentially says the opposite. I can then turn to the TDC case.
Would you accept that, although the means may not be exhaustive, they have to be to the extent necessary to ensure end-to-end connectivity, or necessary to ensure accessibility for end users to digital radio?
If it is a case otherwise within the ambit of 5.1a, I think that must be right, but it is accepted common ground in this case that we're not within 5.1a. The TDC...
Sorry to interrupt, that is precisely not common ground, that is the whole of a battleground between us.
Well, I have to say it comes as news to me that it is suggested that we are within 5.1a. Indeed, I can find the references for you, but from recollection, is that the point is made explicitly by my learned friend that nobody says it comes within 5.1a. But at any rate, I'll be handed the references on that, and I can deal with it in due course. My Lords, I turn now to the TDC case, which is at tab 11. Well, actually, I should pick up the facts again because they're a little more detailed in the Advocate General, tab 22, electronic bundle, page 1317. And if we go, please, to paragraphs 5 to 7, page 1317. TDC is the long-established Danish telecommunications operator, for which reason it is now an operator with significant market power, specifically in the market for broadband connections. In 2009, they had purchased a fibre network for a certain amount, and that made them an operator with significant power. In paragraph 7, the NRA, in that case, imposed on TDC various obligations. And the first point to note about this is a case about SMP obligations. So it's not an Article 5 case, but I do rely on it, both for what it does say about Article 5 in the course of the reasoning and for what it says about the definition of access, as I'll show you in a moment. But the first point to note is that in terms of the obligations in issue, it was an SMP case. So those are the facts. We can then pick up the reasoning of the CJU, which is in the judgment in Authorities tab 11. At page 1024. And the part I wanted to pick up was paragraph 31. At page 1032. Well, actually, I should show you the obligation that was actually imposed. Page 1030, paragraph 19, fourth line. That obligation included, inter alia, the installation of drop cables over a maximum distance of 30 metres in order to connect the end user to the fibre optic network that serves to provide high-speed access. So the obligation imposed in this case was to install new cables up to a distance of 30 metres to reach the network termination point of the relevant customers. If we then go to the reasoning at page 1033, paragraph 32, there's reference to the concept of access. It therefore follows from the wording of Article 2A of the Access Directive, first, that the concept of access includes making adjustments in order to make available to another undertaking facilities and or services for the purpose of providing electronic communication services, because that's what we say. And secondly, that the list of forms of access set out in that provision is not exhaustive. So again, a reference to the breadth of the concept. They then say Article 2A does not specify, however, whether access within the meaning of that provision may include the drop cable between the distribution frame of an access network and the network termination point at the end user's premises, which is necessary to implement access to the existing network. In those circumstances, in order to interpret the concept of access to specific network elements and associated facilities as referred to, it's necessary to examine the definition of access provided for in Article 2A in light of the scheme of and the objectives pursued by that directive. Paragraph 30. The following paragraphs discuss the wording and the objectives of the relevant parts of the framework. And then at paragraph 37, it is apparent from those provisions that the concept of access within the meaning of the Access Directive may include an adjustment to an existing network to enable the establishment of a link between that network and the end user. As regards the objectives of the Access Directive, and then there's a reference to Article 1. Then there's a reference to Article 8. And at paragraph 41, materially for present purposes, the Court says again, with regard to Article 5.1 of the Access Directive, the Court has held that it is apparent from its wording that NRAs are responsible for ensuring adequate access and interconnection and also interoperability of services by means which are not exhaustively listed there. And the reason the Court identifies that under Article 5 is that it then relies on that as the basis for a like implication into the provisions of the rest of the directive. It should similarly be held that the obligations to meet reasonable requests for access to and use of specific network elements and associated facilities, which may be imposed on operators with significant market power on the market, are not exhaustively defined but fall to be prescribed by the NRAs on a case-by-case basis. And then the Court finds that this extension, this installation of drop cables is permitted. It can be ordered by the NRA. So just pausing there, TDC makes clear that if the customers in the data centre had their servers somewhere that was not already connected to anybody's fibre optic network, the GRA could order GIB Telecom to install new wires and cabling to the relevant customers' network termination points to enable competitors such as GibFibre to deliver electronic communication services to those customers. But the argument before you is that because GIB Telecom has already established such a connection by way of internal cabling in a data centre which it owns, the regulator is unable to intervene. And we say that's a proposition which simply doesn't make any sense in terms of the competition objectives which are pursued by the CRF. I then come to the KPN case, which is at Authorities tab 9. And page 961, please. This was a case in which KPN, which was the Dutch incumbent telecoms operator, was ordered not to charge more for call transit services to non-geographic numbers than to other ones. And the Court held that that could be imposed by a combination of Articles 28 of the Universal Service Directive and Article 5 of the Access Directive. And we can see the first and second questions for the Court at paragraph 29 on page 998. This is in the judgment of the Court.
Sorry, page?
Page 998. Now, it may make sense actually to start with 31, which tells you what Article 28 of the Universal Service Directive actually said. That's page 998. Article 28 of the Universal Service Directive provided that member states are to ensure that where technically and economically feasible, and except where a called subscriber has chosen for commercial reasons to limit the access of callers located in specific geographical areas, relevant national authorities take all necessary steps to ensure, in particular, that end users are able to access and use services using non-geographic numbers within the EU. So it's a very general provision. Didn't say anything about price controls. And the question arose, can such price controls be imposed, nevertheless, under the CRF? And the answer begins at 32. Neither Article 28 nor any other provision of that directive specifies, 1, what is meant by all necessary steps, 2, the nature of those steps, or 3, whether the NRAs have the powers to take such steps, with the result that the question arises as to whether a tariff obligation such as that at issue in the main proceedings can be imposed for the purposes of attaining the objective referred to in Article 28. In those circumstances, it is necessary to examine whether the Framework Directive and the other specific directives, which form a harmonised framework, contain information which makes it possible to answer that question. There's then reference in 33 to the objectives of the framework. I think I can move forward to 35. The first paragraph of Article 5.1 of the Access Directive refers to the powers and responsibilities of the NRAs in respect of access and interconnection. That provision provides that acting in pursuit of the objectives set out, and then there's a reference to Commission of Poland, which I needn't read again. And then at 36, it must be borne in mind that the Court has already held in this regard that it follows from the wording of the first subparagraph of Article 5.1 of the Access Directive that the NRAs are responsible for ensuring adequate access and interconnection, also interoperability of services by means which are not exhaustively listed there. So the same point. There's then the same language that we saw in Telia Sonera in that context in accordance with point A. There's reference to Article 5.3 again. In 39, there's confirmation that those provisions allow NRAs to take steps with regard to an undertaking that does not have significant market power but controls access to end users. That's a 5.1a point. Then, in 41, in accordance with Article 8.3 of the Access Directive, without prejudice to certain provisions, including Article 28 of the Universal Service Directive, I pause there to note that, of course, another of the provisions referred to in Article 8.3 is Article 5, as your lordships have seen, containing obligations on undertakings other than those designated as having significant market power. The NRAs may impose obligations relating to price control, as defined in particular in Article 13 of the Access Directive, only on operators designated as having significant power. Consequently, as the Advocate General stated in paragraph 47, Article 8.3 of the Access Directive should be interpreted as meaning that except under certain provisions, including in particular Article 28 of the USD, you can't impose price control obligations save where there's SMP. Accordingly, 8.3 does not preclude the imposition of obligations related to price controls, such as those referred to in Article 13.1. And then there is reference in 45, 46 and 47 to Article 5 and Article 8 setting out the procedure to be adopted, all the various safeguards I spoke about. So the finding, despite the fact that neither Article 28 of the Universal Service Directive nor Article 5 of the Access Directive referred to price controls at all, the finding of the Court is that the generality of the provisions and the powers which they confer is such that those provisions together empower the imposition of a price control, even where there's no SMP, if the circumstances demanded it. And Polcomtel, in tab 10, electronic bundle, page 1011, is a similar case. The Polish regulator had imposed a price control on Polcomtel, limiting what it could charge its users for making a call to a non-geographic number on the Orange Polska network. And it was held again that Article 5.1 allowed that in conjunction with Article 28 of the Universal Service Directive. You can see the questions at paragraphs 24 to 25, page 1017. There was an issue, as you can see in 23, about the temporal and material scope of EU law in relation to the accession, not accession arrangements, the expiry of the time for the Better Regulation Directive, but that doesn't concern us. 24 and 25, the referring court seeks to know whether an NRA is empowered under Article 5.1 of the Access Directive to impose obligations on operators aimed at implementing Article 28 of the Universal Service Directive. It has doubts in that regard, inter alia, due to the obligation to take account of the freedom to conduct a business, Article 16 of the Charter, and reference then the third question at 25 as to the interrelationship with the SMP regime. The answers we can find at 41 onwards, page 1020, and I can pick it up at paragraph 43. Article 5 of the Access Directive addresses powers and responsibilities, etc. There's then a recitation of what Article 5 says, and again, I, of course, rely on paragraph 44. The Court has already held in this regard that it follows from the wording of the first subparagraph of Article 5.1 of the Access Directive that the NRAs are responsible for ensuring adequate access and interconnection and also interoperability of services by means which are not exhaustively listed there. And we then see the same point about except under as a result of Article 8.3 at paragraphs 50 to 51, page 1021. Particularly 51, Article 8.3 of the Access Directive should be interpreted as meaning that except under certain provisions, including in particular Article 28. So that reasoning applies equally to Article 5, because that's another of the provisions specified. And of relevance to the point about the investment in the data centre, the Court went on in paragraphs 60 to 61 to consider the point that had been raised about Article 16 of the Charter of Fundamental Rights. Paragraph 60, page 1022. According to settled case law, however, the freedom to pursue a trade or profession and likewise the right to property form part of the general principles of European Union law. Those principles are, however, not absolute, but must be viewed in relation to their societal function. Consequently, the exercise of the right to property and the freedom to pursue a trade or profession may be restricted, provided that any restrictions in fact correspond to objectives of general interest, etc. Paragraph 61, it is common ground that the decision of the President, etc., was adopted on the basis of national legislation transposing inter alia the USD and the Access Directive, and is in line with an objective that is generally recognised by the European Union. In that case, access to non-geographic numbers. Accordingly, that decision does not disregard the freedom to conduct a business, provided that, as stated above in 55 and 56, the obligations imposed in the course of resolving a dispute were necessary and proportionate, which it is for the referring court to verify. So the court is making the point there that it is inherent in the regulatory scheme that what would otherwise be private law rights are to some degree affected by the regulatory scheme. And so long as the obligation is imposed in accordance with the regulatory scheme, there can be no objection. So those 4 decisions I've shown you are all, we say, inconsistent with, and indeed explicitly reject, the proposition identified at paragraph 15.2 of the agreed list of issues. Now, as I understood it, Sir Peter's answer...
Sorry, if I can just...
Yes, my lord.
If I could take you back to the TDC case.
Indeed.
I don't think I understand the facts, and you may well be able to help me. I'm looking at page 1031
Yes.
in the electronic bundle.
Yes.
And we're told that this was to do with a request for interconnection from another operator. And the problem, we're told, is that in Denmark, paragraph 23, the fibre optic network is not connected directly to the end user at the time of its initial installation. And the questions posed in paragraph 25 then ask whether
my lord, I'm afraid I've not heard the last 30 seconds of your question.
I'll speak up, Sir Peter.
Sir, I lost the microphone connection, not the...
I was going to the facts of the TDC case at page 1031 in the electronic bundle, and looking for some help from Mr. Segan in understanding them. The questions are framed in terms of installing drop cables, whatever those may be, between the distribution frame in an access network and the terminating segment at an end user's premises. Can you translate into ordinary English, Mr. Segan?
Let me attempt it. And I'll look for it, but I think there's some assistance in the Advocate General's opinion on the point that your Lordship is making. But as I understand the facts of the TDC case, this was a case in which there were already non-fibre optic connections to the customer's homes, or premises. So as there is to all of our homes, there was a basic copper connection, and that was the position. However, the fibre optic network was not automatically connected to each of the customers' homes. And TDC acquired a competitive advantage in terms of delivering the electronic communication services from knowing exactly when the fibre optic connection in the course of the rollout would actually happen. And one can see that from paragraph 46 in the court's judgment. Because of the particular way in which TDC's fibre optic network is constructed, TDC controls when households may be connected, which gives it a definite competitive advantage in the acquisition of new customers on the retail market, inasmuch as the new customers are contractually tied to TDC for a minimum period of 6 months. The obligation on TDC to install drop cables is therefore intended to ensure that competing operators are on equal footing with TDC and can use TDC's network in the areas in which it's being deployed. In respect of final customers who are not yet connected, the installation of such cables is an essential condition for operators competing with TDC to be able to acquire customers by enabling them to offer services distributed by means of the fibre optic network. So the drop cable was the piece of equipment or apparatus or wiring that connected the fibre optic network to the network termination point of the customer. That's as I understand it, my lord.
I see. Thank you.
Now, as I understood Sir Peter's answer to these cases, it was that the CJU was saying that the means are non-exhaustively listed in Article 5.1, but the purposes are exhaustively listed. Now, the problem, of course, with that submission is that the purpose of Article 5.1 is identified in the first subparagraph, which is the one that the CJU has identified as a general power, and of which the non-exhaustive means in the following subparagraphs are simply examples. It's not possible to read the subparagraphs as exhaustively specifying the purposes of Article 5 either, because the starting wording of Article 5 is quite clear. That's the purpose. And indeed, for good measure, that's what the Court of Justice said in Commission and Poland. That then brings me to the fourth flaw in relation to issue 1, which is that the GRA's submission would be inconsistent with the context and the objectives of the CRF. I've already made the point this morning and indeed yesterday afternoon. We've set out the points on that in paragraph 22 of our written case. The short point, which I've now made a number of times, is that the GRA's construction would leave an NRA powerless to respond on a case-by-case basis to sets of facts that don't fall within the 3 stipulated cases. And in accordance with the recognised approach to interpretation, one shouldn't adopt such an interpretation. So that's why we say the GRA is clearly wrong on issue 1.
Are you going to help us with the points that Sir Peter made?
Indeed.
Interconnection with the very elaborate SMP regime.
Yes. And indeed, my Lord, I was about to turn to those precise points. I need to pick up the points that Sir Peter made in his oral submissions. The first point was Article 8.3, the last paragraph, and that's electronic bundle, page 608. And Sir Peter relied on the paragraph next to M1 in your Lordship's bundle at page 608, which says, in exceptional circumstances, when an NRA intends to impose on operators with significant market power obligations for access or interconnection other than those set out in Articles 9 to 13, it shall submit this request to the Commission, and the Commission has to decide whether they can do it or not. And Sir Peter said that that was a provision that the Court of Appeal's analysis could not survive. We respectfully submit quite the contrary. It's a provision that the GRA's case cannot survive because, as we know, a central plank of the GRA's case is that access obligations on SMP operators are dealt with exclusively by the SMP regime in Articles 8 onwards, and in particular by Article 12. That's the second of the 3 propositions by which the GRA summarised its case. But this paragraph explicitly contemplates that an NRA may decide to impose on an SMP operator an obligation for access which is not within Article 12 or indeed any of the other articles. But on Sir Peter's case, that immediately begs the question, where would the power for such an initiative come from? Because by definition it's outside the SMP regime. And the only sensible answer for that is Article 5.
Well, do you accept that in this case, if the authority decided to impose a requirement, they'd have to get the Commission permission from the Commission?
Well, my Lord, 2 reasons why not. First of all, it's been found that there is no relevant SMP. That was the decision in relation to Article 12. Second of all, of course, the Commission now has no role in that regard.
Right, but as to the first point, it's a bit paradoxical, isn't it, if you can do what you like if it doesn't have significant market power, but if it does, when you would have thought there was more reason to intervene, you have to request the Commission.
Well, my Lord, we don't have the travo on this provision, but of course it is those situations involving SMP which have the greatest potential for an effect on interstate trade, which is traditionally the area where the Commission has a role in supervising most closely the obligations imposed by national regulatory authorities. So that may well be the reason why that exists, but it's no impediment in this case. There's no oddity or illogicality in permitting an NRA to act in a case which ex hypothesi does not have such serious interstate implications. But as I say, in the end, it's not an issue in this case for the two reasons I've given, my Lord. And actually, when one thinks about this provision, as I said, it cannot work with the GRA's case, because the GRA's case was very squarely, there is simply no power under this framework to impose access obligations on SMP operators, save as contained in the SMP obligations. And this is a provision of the directive which expressly contemplates the exact thing that the GRA says can never happen.
So is your point that this subparagraph is predicated on the National Regulatory Authority proposing to take some action within its powers within the scope of the directive?
Yes, my Lord.
And it's only when it's doing that that it goes to the Commission to ask them.
Exactly.
So it needs those powers to start with.
It could only propose, let me find the wording so I'm not doing violence to the provision.
Page 608.
I'm most grateful, my Lord. Sorry. It could only intend to impose on operators with significant market power obligations for access or interconnection other than those set out in Articles 9 to 13 if there were ex hypothesi power under the directive to do so. And the only candidate for that is Article 5. So that's what I say about Article 8.3. Sir Peter then moved on to Gaza Niti.
Well, sorry, just before you move on from 8.3, I think Sir Peter also relied strongly on the end of the subparagraph before that national regulatory authorities shall not impose the obligations in Articles 9 to 13 on operators that have not been designated in accordance with paragraph 2, i.e. as having P.
Yes, my Lord, but that has been recognised to be covered by the without prejudice provision. That's KPN and Polkomtel. Because they both decide expressly that you can have obligations within the ambit of the SMP regime on non-SMP operators.
Well, what function does it serve then? Those words at the end, if you can just bypass them anyway?
It serves a purpose. You can only bypass them under the stipulated provisions earlier in the subparagraph. And that was.
Do you mean the? But that's everything. I thought your case on Article 5.1 is it's a general provision that basically is wide-ranging.
But that is what I say the Court of Justice decides in Commission and Poland about the ambit of Article 5. And then, my Lord, I've shown you KPN and Polkomtel, and we've given the references in our written case. The decision in that case was that obligations, SMP obligations, could be imposed on non-SMP operators because of the without prejudice wording.
So what's taken away with one hand is given back with the other, basically.
Well, my Lord, one has to stand back and ask what approach to the powers can one gather from the decisions that we've looked at. The Court of Justice has been faced in that suite of cases I showed you with a whole series of situations which were not explicitly covered by the powers in question. On each occasion, the Court of Justice's answer has been recourse to Article 5, including in KPN and Polkomtel explicitly in cases where the issue arose, can you impose an SMP obligation on a non-SMP operator? And the answer is yes, you can, under Article 5, because of the without prejudice wording. So I do say that the very clear trend of the case law is in favour of a broad interpretation of the powers of NRAs in order to meet identified problems in competition in the delivery of regulated services. And on each occasion when the Court of Justice has been required to consider a new set of facts not explicitly mentioned in the relevant provisions, the answer has been it's covered by the general power in Article 5.
Is there any case in which it's been held you could impose a conditional obligation on a non-SMP under Article 5 that could not be imposed on an SMP under Articles 9 to 13?
An obligation on a non-SMP operator that could not be imposed under Articles 9 to 13. Well, I think probably that is true of Telia Sonera and of KPN and of Polkomtel, because those are, it's certainly true of Telia Sonera, because that's about interoperability of services with a text message, a software-based text message service. So that comes within the, I'm going to be coming to this, but Article 5(1) refers to interoperability of services, which is relevant on the scope point. But I think certainly Telia Sonera, I'll need to reconsider whether I've maintained what I say about KPN and Polkomtel. But at any rate, obviously, naturally, the question we would submit is one, a principle as to whether the powers permit it or not. And we say, looking at the powers on their proper interpretation, Commission and Poland, it's a broad and general power. The way that Gibraltar has actually implemented this power, there clearly is power to impose what we seek in this case.
And can I ask, is there any discussion in any of the CJU authorities about the interrelationship between Article 8 and Article 5, other than what you've shown us as the indications that Article 5 is broad? I mean, do they discuss the interaction between the regime, which is seems to be a more stringent regime for finding SMP and then imposing SMP conditions, and this wide power under Article 5?
I can't think of any further discussion as I stand here beyond the passages that I've shown to the court, which rely on the without prejudice wording, to say that means that the powers are still available even in respect of non-SMP operators. There's no discussion in the case law of the point that I think Your Lordship is putting to me about how a general power coexists with a much more specific and prescriptive
That's the point that Sir Peter has been emphasising, and yes, most definitely I'm putting to you.
I understand. I'm of course going to be addressing that point briefly, but let me come to that now. We say essentially the two regimes explicitly exist without prejudice to each other. That's in the directives. Article 8.3 says that in terms. KPN paragraph 42 and Polcom paragraphs 50 to 51 say exactly that. The without prejudice wording means except under. Article 5 is a general power to respond to the facts of a particular case where appropriate. Articles 8 to 13 are a more structured mandatory regime requiring specific action in specific circumstances. And as my Lord Sales observed yesterday, they are specific and focused. And the regulator cannot, as Sir Peter suggested yesterday, simply ignore that regime or decide not to follow it. It's bound to conduct the SMP process, but it has the Article 5 power as well on its terms where appropriate and in accordance with the objectives being pursued. Now, coming back to the points that Sir Peter made orally, he referred to Garzaniti and said there was nothing in Garzaniti's third edition which he was citing to support the idea that Article 5 was a broad and general power for the purpose of achieving the Article 8 objectives. And I would simply refer you in that regard to the extract which he handed to you and relied upon, virtually handed, I should say, at page 149.
149 of what?
Of the extract of Garzaniti that has been added. It was the late addition to the bundle.
I think you have to give us a paragraph number because ours is numbered from 1 to 8.
I see. So it would be, it's paragraph 1-237. And on page 149, in the 6th line.
Is this the third edition?
It is indeed, yes. I'm addressing this because it was relied on by Sir Peter. It has been, as we observed, replaced by the 4th edition, but the point was made that there's no statement consistent with our case in this book.
1237.
And in the 6th line, the book says this: Article 5 of the Access Directive provides NRAs with the general power for
I'm sorry, I'm not with you. Did you say 1-237?
I'm afraid I do not have the Garzaniti extract as part of my bundle.
Yes, it's within paragraph 1-237.
Oh, I see.
And then you keep referring to page 149. You mean the internal page of the book. So if you go...
My apologies. Internal page 149.
Yes, got that. Yes, I think we're all with you now.
6th line. Article 5 of the Access Directive provides NRAs with a general power for the purpose of achieving the objectives of Article 8 of the Framework Directive in the specific context of access and interconnection. Furthermore, Member States must ensure that NRAs are empowered to intervene on their own initiative in the situations specified above. Despite the broad discretion granted to the NRAs, Article 5 of the Access Directive must be used with caution, taking into account the general principle of the electronic communications regulatory framework that regulation should only be imposed where necessary and must in any event be proportionate to the market failure identified. So that's my exact point. There are safeguards in the form of the proportionality requirement, the procedural safeguards, but the power is broad. Sir Peter then relied on the UK implementing legislation.
I'm sorry, just before you move on, I'm just reading in the text. I'm looking at footnote 986.
Yes.
What's the Article 7 procedure? That's Article 7 of the Access Directive, is it?
No, I think that's referring to Article 7 of the Framework Directive, which is the provision I showed your Lordships yesterday evening, and perhaps we need to go back to it very briefly, but it requires additional notification and consultation in cases with an interstate dimension. So it is at page 6 638. And you can see Article 7(3) at page 638 says, except where otherwise provided in recommendations or guidelines, etc., where a national regulatory authority intends to take a measure which falls within the scope of Articles 15 or 16 or Articles 5 or 8 of the Access Directive and would affect trade between member states, it shall make the draft measure accessible to the Commission, BEREC, other NRAs, etc.
Thank you.
So that's an additional safeguard in cases with an interstate dimension. My Lord, Sir Peter then relied on the UK implementing legislation. That's Authorities, tab 15, Electronic Bundle, page 1117. We deal with this at paragraph 24.7 of our written case, but we say, again, just like the Gibraltar legislation, the UK legislation is inconsistent with the GRA's case.
So sorry, I missed the paragraph number.
My apologies. It's paragraph 24.7, but I'm going to elaborate that a little bit.
Yes.
Page 1117 of the bundle is where the 2003 Act begins. Now, Sir Peter relied on Section 73 because it says the only conditions that may be set under Section 45 as access-related conditions are those authorised by this section. And it then says access-related conditions may include conditions relating to the provision of such network access and service interoperability as appears to Ofcom appropriate. And then the competition objectives are set out. He then said, and I'll come to that in a moment, but he then said that Section 74, which is over the page, set out the various specific conditions. And because this is the current version of the legislation, it's the specific subparagraphs of Article 61 of the 2018 directive, which correspond and have expanded upon subparagraphs A, B, and B of Article 5 of the directive. So these were, in short, the specific examples of the general power. And one sees at the end of those specific examples, subsection 5, page 1125, this section is not to be construed as restricting the provision that may be made under Section 73(2). So again, just as with the Gibraltar legislation, the express legislative provision is that the examples are non-exhaustive of a general power. Now, one then asks, what is that general power? Well, one goes back to Section 73. It's a power to set conditions relating to the provision of such network access as appears to Ofcom appropriate. That was relied upon. But one then needs to go to the definition of network access, which is at 1134. Subparagraph 3. In this chapter, references to network access are references to interconnection of networks, any services, facilities, or arrangements which, one, are not comprising interconnection, but two, are services, facilities, or arrangements by means of which a person is able, for the purpose of the provision of an electronic communications service, to make use of anything mentioned in subsection 4. Subsection 4, the things referred to in subsection 3b are any electronic communications network or electronic communications service any apparatus comprised in such a network or used for the purposes of such a network or service, any electronic communications apparatus, any facilities made available by another that are associated facilities by reference to any network or service, and then any other services or facilities which are provided or made available by another person and are capable of being used for the provision of an electronic communication service. Again, our precise case as to the proper interpretation of Article 5, and inconsistent with the case advanced before you, not just on issue 1, but on issue 2. Because a network access condition explicitly may extend to any other services or facilities which are provided or made available to another person and are capable of being used for the provision of an electronic communication service.
Not sure I follow. You're wanting access to the room where the racks are so that you can plug into the customer's not routers, but servers. Yes, servers. What is it you say there that's capable of being used for the provision of an electronic communication service?
The whole of the arrangement is it is common ground that the whole of the arrangement is used for the delivery of electronic communication services, because that is what both Gib Telecom and Sapphire are doing within the data centre, and that's an agreed fact.
Yes, but you're not interested in their networks. You're wanting to be able to plug your network into customers' servers. Because yeah. I know they're sitting in a room with climate control and dust control and so forth. There's nothing in that room that's being used for the provision of an electronic communication service, is there?
The racks and the cross-connect wires as I say, it's an agreed fact that they are being used for the delivery of electronic communication services, and that they are a facility capable of being used for the provision of an electronic communication service.
You can find it where it's an agreed fact.
Facts and issues. Paragraphs 3 and 4. Line 5 of paragraph 3 on page 508. At the data centre, customers requiring very substantial bandwidth in order to operate place their servers and related equipment. Gib Telecom then provides electronic communication services to those customers through Gib Telecom servers. We then have the last sentence of paragraph 4.
But you're not trying to make use of what's provided by GibTel. You're not trying to make use of the electronic communication services provided by GibTel.
No, we wish to provide electronic communication services, and we wish to have access to a facility or service capable of being used for the provision of an electronic communication service, which is what both the definition of access in Article 2, subparagraph A of the directive, and the definition of a network access condition in the UK legislation, and the definition of a permissible provision under Regulation 6 of the Communications Regulations 2006 in Gibraltar, all provide for.
So is this the point that you're making? We look at paragraphs 3 and 4 of the Statement of Facts and Issues. We see that both Gib Telecom and Sapphire, when they connect through to the customer's servers, are providing electronic communication services. You say GFS wants to do the same, i.e. to provide its own communication, electronic communication service.
Yes, and using the very same racks and cross-connect wiring. This is why I took the trouble to
sorry, just to finish, just to get it clear in my mind.
Sorry, my lord.
And then looking at subsection 4D, you're saying that the racks, the setup in the data center, is a service or facility which is capable of being used for the provision of an electronic communication service. It's already being used for such services by Gib Telecom and Sapphire, and it's capable of being used for the electronic communication service you want to provide.
That's right.
That's the way your point works.
That's why we say we're within the definition of access. Indeed, it's why I took the trouble to show your lordships yesterday, I think paragraph 20 of Mr. Justice Butler's decision, which emphasises that it is the very same wires that connect Sapphire's server to the customer servers as connects Gib Telecom's server to the customer servers. It's the internal wiring of the data center. So, and as I say, there hasn't actually been any dispute, certainly no submissions advanced, to the effect that what we are seeking is not access within the meaning of Article 2A of the directive. The argument instead has been that there are other restrictions. The two issues seek to cut that down. The first issue seeks to cut it down by saying Article 5.1, subparagraph A, B, and B are exhaustive. The second seeks to cut it down by saying that Article 1 of the directive cuts down the scope.
Well, it defines the scope.
Well,
scope of directive.
I'll obviously be answering that point, my lord.
And when you say it's not in dispute that it's covered by Article 2A, I thought that was in dispute partly for the scope reason that you have to read Article 2A as subject to scope. Point.
In which case, I'm sorry, my lord, I should have been clearer. Subject to the point on scope, right. There is no dispute that we're within Article 2A of the Access Directive. But at any rate, when one looks at this definition of network access, it's completely inconsistent with the idea that A, B, and B are exhaustive. Just as the Gibraltar legislation is. Sir Peter then relied on the BT and Telefonica case, which we deal with in paragraph 8.6 of our supplementary written case. The short points are there. We say one cannot read Lord Sumption's paragraph 11 as indicating that the subparagraphs of Article 5 are exhaustive. That's not what he says. It wasn't in issue in that case, and it would have been inconsistent with some of the judgments he was citing, and which I've shown you, including Telia Sonera, which decide the opposite. His focus naturally was on interconnection, which is a subset of access because that's what the case before the Supreme Court was about. But there is no finding to the effect that A, B, and B are exhaustive, as we set out in paragraph 8.6. Apologies, my lords, I'm making sure I'm going to have sufficient time to deal with issue 2, which I know you're keen to hear from me on. So, yes, I do just need to pick up one point, which is in paragraph 21.6 of my learned friend's written case, where he submits that the 2018 directive contains some relevant limitation in relation to the subparagraphs So I just need very quickly to show you that. That's at electronic bundle page 772.
My lord, I could save my learned friend some time. That is part of what I had tried to withdraw. The whole reliance on the point that the EEC somehow bolstered my case. My learned friend need not concern with that if he doesn't want to. I have withdrawn that.
Thank you, Sir Peter. That's helpful.
I'm most grateful.
But I think Sir Peter did rely on some Commission guidelines. I don't know if you wanted to say anything about those.
Yes, well, I essentially rely on the reasoning that's in the judgment and in our written case on that issue. There's the relevant paragraph 4.3 expressly uses the word inter alia in relation to Article 5, which is consistent with it being a general power. And in any event, of course, I make the point that they are ultimately Commission guidelines and don't carry the same status as the decisions of the Court of Justice, which I've shown you. That brings me then, my lords, to the second issue.
Sorry, just on that, what was the date of the Commission guidelines? They were quite early, weren't they?
I think they were 2003, my lords. Let me check that.
So does that mean that they don't take account of the case law that you've been showing us?
Let me check that, my lord.
It's 2002, my lord, the 11th of July, 2002.
That's pages 208 and following, my lords. So, in fact, I had post-dated them. They're in fact 2002. So, they're at the very start. They therefore predate all of the authorities I've shown you.
And the Commission was arguing, was it, for a view, for the exhaustive view, which was rejected? Is that part of the story?
Well, as I say, I don't accept necessarily that the Commission guidelines bear the interpretation that they have been given, to the effect that they are espousing an exhaustive interpretation, because they do, as I say, use the word.
No, I'm referring to one of the cases you showed us where the Commission was making such an argument.
Your Lordship is absolutely right that if the guidelines do bear that interpretation, that is the argument that was advanced before the Court of Justice by the Commission in Commission and Poland and rejected.
Thank you.
My Lord, the second issue in the appeal can be seen at paragraph 16 of the Statement of Facts and Issues, which is in the Key Documents Bundle, tab 1, electronic bundle, page 510. Does Article 5 of the Access Directive endow the appellant with the power to require an operator to allow access to physical infrastructure, even where the relevant infrastructure, and then there's a part that we've been unable to agree, and I'll explain why in a moment, could not be described as being part of GIB Telecom's own network or associated facilities? And the reason for that disagreement is the point that I mentioned yesterday afternoon about the ducts. The request for access has been analysed as having three elements, which the Court of Appeal summarised at paragraph 37 of its decision, which can be found at electronic bundle page 25. Both counsel accepted that one can unpack three elements in this access request. First, GFS wished to have access
Sorry, you're reading from paragraph.
I'm so sorry, my Lord.
37, thank you.
It is indeed. Paragraph 37, page 25. First, GFS wish to have access into Mount Pleasant and to use certain ducts which are used by GibTel as part of its network. Second, it wishes to place its server onto the data rack. Third, it then wishes to connect its server to the other servers, also using the rack. So those were the three elements. And then you can see from the next paragraph that it was accepted by the GRA that the first element, the ducts, are associated facilities because they can be used by GibTel for its own network and therefore can, in principle, be used by GFS. That's the point as regards the first element. The Court of Appeal proceeded on the basis of that concession. We've made clear from the outset that we rely upon it, and neither GRA nor Gib Telecom has sought to persuade you that the concession was wrong. So the case for the GRA and Gib Telecom has to be that the entirety of a request for access to physical infrastructure must be to a public network or an associated facility. It's not enough that the request in part concerns such infrastructure, as it indubitably does in this case. And the GRA's submission on this point is encapsulated really in paragraphs 26.3 to 26.4 of its written case at tab 2 of the key documents bundle, electronic bundle, page 533. 26.3, the access requested always has to be to infrastructure that either constitutes electronic communications network or an associated facility of an electronic communications network. It cannot be to a building that is neither of those things. So this second issue arises because only part of our request for access relates to a network or an associated facility. The second and third elements don't, on the findings of the Court of Appeal. And their reasoning in that regard is set out in paragraphs 36 onwards of the decision. Sorry, 38 onwards. I should just mention briefly an important point.
Sorry, just can I check? But in order to be any good to you, the access has to comprehend all three elements, doesn't it?
Yes, my Lord, and that's the point the Court of Appeal made. But the issue of interpretation is, can an access request ever go beyond a network or an associated facility, or is the infrastructure that the access request can touch required always and in its entirety to comprise a network or an associated facility?
But if the issue is, can a request ever go beyond a network or associated facility, in the sense that aren't the ducts a bit of a red herring? Because suppose you didn't need ducts, so everything that you were asking for was something outside a network or associated facility. Help me, wouldn't you then still be saying, well, we still want to come in?
That's right, my Lord, and we would still be saying that that is access within...
Yeah.
Yes.
So you're not making an argument that if you get a foot in the door, you can prise it all the way open, as it were.
Yeah, that's what I was driving
Well,
at.
I don't think I would disavow that point, my Lord, but because we do rely on the fact that the ducts are an associated facility. But my construction point, Your Lordship is absolutely right, goes further than that if it needs to. But properly understood in this case, the issue is simply, can an access request ever range wider than an associated facility or a network? Now, I need in that context to explain a point which arises on paragraph 36 of the Court of Appeal's judgment, because the Court of Appeal said this at 36. It's pertinent to note that GFS is not seeking access to the network itself. It is common ground that it would be entitled to such access by virtue of Article 4. Then there's a reference to interconnection. If GFS had chosen that route, it could then undoubtedly link with the other servers on the data centre, but it's chosen, no doubt, for commercial reasons to eschew that path. Now, I do need to address that because, and it's relevant to some of the submissions that Mr. Palmer made to you yesterday about the internal workings of the data centre. In fact, my client has always been perfectly content, if necessary, to accept connection by way of a leased line. And indeed, 3 months after the Court of Appeal decision in this case, the GRA decided that GIB Telecom must provide access to the servers in the data centre by means of a leased line. But GIB Telecom has appealed that decision, saying that the GRA cannot require access by means of a leased line either because the data centre is not part of its network, relying on the same findings in the Court of Appeal decision. So GIB Telecom's position is that there is simply no way that its activities within the centre can be touched by the regulatory scheme at all. Every time my client asks for access, the answer is no for a new set of reasons. But the reason I raise that is this. That appeal has been stayed pending the present appeal. I emphasise that because yesterday Mr. Palmer made various submissions to your lordships about the mechanics of the data centre. And I make no criticism whatsoever of him in that regard. He did so in response to a question from my Lord Reid. Yes. So this is not a criticism in any way.
Well, I think it's important we do understand the facts of the case.
And I quite understand that, my Lord.
We haven't got a diagram, we haven't got photographs, so there has to be a verbal description.
Quite so, my Lord. But in that regard, particularly given the existence of the stayed leased line appeal, I do emphasise that what Mr. Palmer told you is not to be found, as your lordship recognises, in any of the evidence or the findings before this court. And in various respects, particularly as to the location of the network termination point or points, he touched on topics which are hotly in dispute in the leased lines appeal, which is presently stayed, and in which indeed there are competing experts addressing whether a carrier room is required, one of the things that he mentioned, where the network termination point or points actually are. And there was a suggestion that what we're asking for in effect would be a very substantial incursion into the data centre. There was a suggestion that we would need a carrier room or a meet-me room, as it's sometimes called. We don't accept that. Our server, this is in fact what the Court of Appeal says when it summarises the requested access. It says that the server would be on the data rack, which is the same rack as the customers, the gaming companies, as one can see from paragraph 41 of their decision, either allowing GFS's server to be placed on the rack or linking its server with other servers hosted there. Indeed, it's important to note that we say that describing it as our server is actually, to an extent, something of an overstatement anyway. I'm instructed all we need is a passive patch panel which sends the messages from the servers to the network. But the reason I make this point is that one has to be, in my submission, and I would respectfully ask the board to be, very careful in whatever is said about the underlying facts, because it must be tied to what is in the evidence and the findings in this case, i.e. what's in the Court of Appeal. And I do invite your lordships not to range beyond that into the territory of Mr. Palmer's submissions, precisely because those topics are an issue in the leased lines case. Yes, of course.
Be required for this. I was just simply making the point. GIB Telecom have a carrier room, Sapphire have a carrier room. It connects to the customer suites. That's an accurate description, I believe, common ground as to how the data centre is arranged. I also made the point that there has been no definition of where the network termination point actually is. But what I did submit to my Lords is, for my Lord's purpose, that doesn't matter, because on any view, what is being sought is to connect to the customer service on the other side of the network termination point, wherever it is. And I took that from the Court of Appeal, which you'll see at 39, paragraph 39 of the Court of Appeal, the reference to the network termination point. That point didn't seem to be in dispute at that stage. So I didn't seek to incur into territory of another appeal, which has been stayed, but just to describe the existing situation. I hope that helps.
Well, surely on any view, the service can't be regarded as part of the customer service can't be regarded as part of the public communications network.
No, that's right, my Lord. And indeed, that's what the Court of Appeal find in the relevant paragraphs of their decision.
And you're relying, insofar as access can be either to networks or associated facilities, it's the associated facilities side of that you're relying on.
It's part of it, but my Lord, we do those are essentially.
Well, the trouble is, if you get into the access to operators network, then operators defined in terms of public telecommunications network, and you've entered into the definition about network termination points.
Yes, my Lord. This comes back, I think, to my answer to my Lord Legate's question a moment ago about the two layers and the foot in the door. The primary position, as a matter of construction, is that Article 5, read with Article 2A, empowers an NRA to impose whatever conditions it likes to achieve access in the full breadth of that definition in Article 2A, which is not limited to access to network elements or associated facilities. That's the first layer of argument, and we say that Article 1 does not cut that down. The second layer of argument, if necessary, is that part of this access request does relate to an associated facility, and therefore the only question is it permissible for an access request to go beyond a network element or an associated facility? And we say clearly it is, when one looks at the definition of access, and indeed when one looks at the legislative provisions in Gibraltar and in the UK that I've shown you earlier today.
I don't at the moment understand how 2 will assist you if you don't succeed on 1. Lumbering your points 1 and 2.
Well, it goes to the question that I was asked by my Lord Sales. What if all 3 elements were outside?
Yes.
And it would be possible, if limb 2 of the argument is correct, to succeed given that one of the 3 elements is an associated
facility. There's no logic
facility.
in that. At least I can't see any. The foot in the door point, that if you get your foot in the door, the whole door swings open. Because how does the fact that the ducts come within it help you when you have to deal with elements 2 and 3? It can't make any difference either way, can it? Just gets you over the first hurdle, but you've still got the other 2 to jump.
Well, it raises I don't want to spend too long on this, because I say the first primary position is the first layer of argument, which is the non-foot in the door point. But just to address my Lord's point on the associated facilities point, it would raise a different question of construction, not as to whether a request for access may relate in its entirety to elements which are not network elements or associated facilities, but rather only can it extend beyond, in part, an associated facility. So that's the second layer of argument. But as I say, I don't want to get detained for too long in that point. Let me address the point of principle, which is this. Under issue 2, the GRA and GIB Telecom seek to rely on the findings of the Court of Appeal in the paragraphs that we've just seen that begin with the 3 elements of the access request, in essence to say that it follows that the data centre is out with the regulatory scheme entirely. It is, as I mentioned yesterday evening on their case, a regulatory no-go area, because Article 1, they say, says that the directive harmonises only access to networks and associated facilities. And we say, in essence, that that seeks to spell a meaning or effect out of the very general provisions of Article 1 of the Access Directive that they cannot, that those provisions cannot fairly bear when analysed in the context of the provisions of the same directive and the CRF and its wording and purpose. So let me address in turn the wording and then the purpose. On wording, it's axiomatic that one has to read the Access Directive as a whole. And indeed, in this case, the CRF as a whole. And when one does so, we say it's clear that the contention that an access obligation under Article 5 cannot touch anything other than a network element or an associated facility is wrong. And the starting point is the definition of access itself, which we've already been to, but I can go back very briefly at page 604. I know your lordships are very familiar with it by now, but I need to turn back to it briefly. Access means the making available of facilities and or services to another undertaking under defined conditions on either an exclusive or non-exclusive basis for the purpose of providing electronic communication services. So that is those words, opening words, are the operative definition of what access is. It states the what, facilities and services. It states the to whom, another undertaking. It states the conditions under defined conditions, so that's obviously to be set by the regulator, and it describes the purpose, for the purpose of providing electronic communication services, including when, etc. There is then what the Court of Justice found in TDC was a non-exhaustive list of things that it may cover. It covers inter alia access to network elements and associated facilities. But then there are a whole series of other things, and we also know from TDC that that is non-exhaustive. It may include, as the court found in that case, an obligation to make a modification, to lay new cables or the such like. But the operative part of the definition is the bit that comes before it covers. And the difficulty with the case that's put before you on issue 2, I submit, is that if Article 1 really were a provision which cuts down the vires afforded by the remainder of the directive in the way that is suggested, then this definition simply couldn't have been written as it is, because it has access to network elements and associated facilities as one example of the facilities and services comprised within the concept of access. Now, a number of answers were suggested to this. Sir Peter's answer was based on purpose. He said that this definition is limited by the purpose identified in Article 1 of the directive, but that's not reconcilable with the terms of Article 2A itself, which identify the purpose expressly for the purpose of providing electronic communication services. The second answer was surplusage. It was said that the definition of access after access to network elements and associated facilities is surplusage or duplicatory. Well, that's, in my submission, extremely unlikely. And what's more, the point goes rather further than that, because on GRA and Gib Telecom's case, you would also have to, or at least you could perfectly well, remove the words which precede those words, access to network elements and associated facilities, including the words inter alia. Because on the scope point, the effect of Article 1, so it is said, is that in fact this definition simply means, it could simply have said access means access to network elements and associated facilities. But that just can't, well, it simply makes no sense in my submission, and it robs the actual operative provision of the definition of any real effect.
I suppose you can say in relation to Article 1(2 that the first sentence is talking about rights and obligations for operators, which corresponds to Article 4, I think. And then it goes on to say it sets out objectives for national regulatory authorities with regard to access and interconnection, using the term access generally.
One could,
which the rest of the, which the provisions on national regulatory authorities sets the scope for them.
one could certainly say that, my lord, but one could equally say, as I say, that it is a very general statement of the aims, as it were, of the directive, but that the ambit of the powers under the directive is to be determined by reference to the operative provisions which actually confer those powers, in our case, Article 5, and that one cannot read Article 1 on its own. One has to read it in the context of the directive as a whole, and it's perfectly plain from this definition that it was intended to go wider than simply access to network elements and associated facilities.
I suppose you might also say, is this right, that if you look at recital 3 of the Access Directive, where it said it's necessary to define precisely how that term is used in this directive, that, well, I suppose it might be said that that gives a particular emphasis to the text of the definition of access when one's trying to work out the meaning of that and indeed its place within the directive as a whole.
Yes, indeed. This is specifically identified by recital 3 as what is intended to be a precise definition of access. And there is, in my submission, no way that it can work with the scope point. Indeed, I should observe this, that it would also, were it correct, the regulatory schemes, the domestic legislation that we've looked at in Gibraltar and in the UK would have got things dramatically wrong. Because, as we've seen in both Gibraltar and in the UK, there is a general power to set access-related conditions, which in both cases goes beyond, explicitly beyond, network elements and associated facilities. So those provisions on my learned friend's case on issue 2 would be ultra vires. Now, the third answer that was suggested to this point was the what access to what question. The definition doesn't define what the access relates to, but it does do precisely that, as I've pointed out. It says access to, let me find it, facilities and services for the facilities and or services for the purpose of providing electronic communication services. So it defines the what and the purpose, and as I say, that's the way it was understood in Gibraltar and the UK. But it's not just the definition of access that confirms that this submission is wrong on issue 2. One also can look, for instance, at Article 5 itself, because Article 5, and this is not something we've focused on a great deal so far, Article 5 in the 5th line imposes the obligation on NRAs, where appropriate, in accordance with the provisions of this directive, to ensure adequate access and interconnection and the interoperability of services. And as we saw, a service, as in Telia Sonera, might be a software-based text message service that never touches anybody's network. Again, a provision that...
I'm sorry, you're going to have to assist me with that just for reasons of technical ignorance.
Okay. Well, Telia Sonera was about access to a network by a software-based text message service. The definition of electronic communications service covers a whole range of activities which is considerably wider than those delivered via a network. Or it doesn't require, you can deliver electronic communication services without having your own network, like IMES did. This provision on its face enables two people who deliver electronic communication services only to be ordered to render their services interoperable. There's no reference to network in there. If it were to do with networks, again, it would be surplusage. There's then the point that interconnection...
But when you say interoperable, does that mean that one can speak to the other?
Yes, exactly.
So if I've got an O2 phone and you've got a Virgin phone, we can still communicate?
That's right, my lord. Your lordship's example has a network element because it's to do with O2, but it could just as easily, because it's about electronic communication services as well, it could just as easily be a service which isn't delivered via a network. And on the face of this provision, there is power to order interoperability of services. Again, not consistent with the scope point. We then have recital 1, which refers to non-public networks being subjected to obligations if they benefit from access to public networks. And I don't accept that that can be read in the way that Mr. Palmer did, as generating only rights for non-public networks, not obligations, because it says in terms, non-public networks do not have obligations under this directive except where, etc.
Sorry, I didn't follow that point. Could you just repeat it for me?
This recital anticipates that a non-public network could be subjected to regulatory obligations if and insofar as it benefits from access to a public network. And if the scope point were correct, in that an access-related condition can only ever relate to a network or an associated facility, that would be impermissible. It would be ultra vires because of Article 1. So if one reads this directive as a whole, it simply doesn't support the idea that an access obligation under Article 5 can't touch anything other than a network element or an associated facility. And it would require a complete rewriting of the definition of access to give it that effect. That's the wording. I turn now to the purpose of the CRF. Well, I've already, to a great extent, made my submissions on that. The central purpose of the CRF is, as I've shown you, to promote competition in the delivery of electronic communication services. And yet the GRA and GIB Telecom's interpretation would, everyone appears to agree, leave the GRA completely powerless to prevent what it has already assessed to be a serious distortion of competition by the creation of a no-go zone for regulation in Gibraltar. And to leave it to GIB Telecom to decide who all these customers can get their services from and on what terms.
I thought we were told that the GRA now has sort of general competition regulatory powers. Is that?
That is right, but that would, I mean, I haven't studied those in detail, but that would obviously relate to a competition enforcement investigation, and then there might be a whole range of things that could be ordered, that could be perhaps be fined or the such like. But it'd be very odd indeed if the conclusion were that the regulatory framework for telecommunications, the specific bespoke framework which is supposed to deal specifically with communications and to further competition, afforded no power to deal with the situation that we're concerned with. And the availability of ex post competition law is no answer to that. Indeed, it's a point that the Advocate General made in the Commission and Poland case that I showed you earlier, that the whole reason that the CRF was brought into existence is because ex post competition law is not a satisfactory remedy in markets where historical incumbents like Gib Telecom and British Telecom are endowed with historical advantages. And one only needs to look at the CJU case law to see how important this factor is, because every time they have perceived a lacuna in protection for competition, they have found that the power exists by an interpretation principally of Article 5. So KPN and Polkomtel, there's a price control that can be imposed on non-geographic numbers, even though there is no mention of that in the provision. In TDC, it's found that you can impose an obligation to install 30 metres of drop cable to connect to a fibre optic network, even though, again, there's no mention of that in the access provision. And in Telia Sonera, as I say, there's an order for service interoperability. And it's worth observing that the existence of a data centre is not it's not an idiosyncratic feature of the Gibraltar communications market. It's a feature of markets throughout the EU. And if my learned friends are correct, then the more data centres that are set up, the larger the parts of the market which are foreclosed to effective competition or regulation at all. And as I say, it would be very much inconsistent with the need to promote competition to adopt the interpretation urged upon you. I realise I'm running out of time. One final point on this point. If this scope provision were such a fundamental provision in identifying the vires of national regulatory authorities, one would expect it to have been replicated in the 2018 directive, but it is not. With effect from 21st of December 2020, the Access Directive was repealed along with the rest of the CRF. I'm not going to have time to take you through it, but there is a correlation table appended to the 2018 directive. The articles which are said to correspond to Article 1 of the Access Directive are Articles 1, 2 and 1, 3. They're electronic bundle page 725, and they are simply a statement of the aims of the framework and what the directive is without prejudice to. And we say we're very much within those aims. Then finally, on this scope point, of course, I have the fact that, as I've shown you, the domestic legislation is all absolutely consistent with the case that we advance. As I say, if the case on issue 2 were correct, then substantial parts of the framework in both Gibraltar and the UK would amount to an erroneous implementation. That then brings me finally to the third issue, where I'm not going to make any oral submissions to your lordships because the point simply doesn't arise. We've dealt with it in our written case. The scope or otherwise of Market 4 was an issue that arose in the context of GibFibre's case based on Article 12. That case was rejected by the Court of Appeal, and there is no appeal against that rejection. So even if the GRA were to succeed before your lordships on issue 3, it would make no difference to the case because Article 12 was rejected for other reasons. And in those circumstances, I simply say it's academic. It, as Gib Telecom says in its written case, goes nowhere, and we respectfully agree. But should your lordships wish to see what we say about that, there is an annex to our written case. My lords, unless there are any further questions, those are my submissions.
Well, we won't hold you to that if anything occurs to you over the short adjournment. But we'll adjourn now and sit again at 2 o'clock.